Hello and welcome to the October 2021 episode of My PIP Monthly. My name is Amber Rouse Holloway and I'm a partner here at our Troy office. Our October 2021 topics will of course include a very brief case law update. We'll talk about the case of Down v. State Farm. Then we'll move on to trending topics in PIP litigation and discuss proof of lost wages and the new fee schedule. All right, in the case of Downs v. State Farm Mutual Automobile Insurance Company, which is an unpublished opinion that came out on September 23rd, 2021. Ultimately, this case discusses that when there's a claim for unjust enrichment, the law operates to imply a contract in order to prevent it. Contracts are implied only when there is no express contract covering the same subject matter. In most no-fault cases, obviously, there is a contract that covers the subject matter. Obviously, there is a contract in the form of an insurance policy. So in the case of Downs, the Court of Appeals opined that plaintiff's insurance policy with the defendant was the express contract that covered the subject matter, and therefore a claim for unjust enrichment was just not possible. The Court of Appeals ultimately determined that the interveners in this matter, which I'll go on to talk about in a minute, were attempting to sidestep the No-Fault Act and go after defendant. All right, just by way of background, in the Downs case, the plaintiffs originally were Erica Tyler and Eric Downs, Isaiah Hobson, and Azariah Hobson. They were involved in a motor vehicle accident where their vehicle was rear-ended by a vehicle driven by a Tashawn Woodley. At the time of the accident, the plaintiff Tyler's vehicle, was insured by State Farm. Plaintiffs claimed that they were injured as a result of the accident and sought treatment from several providers. These are the providers that eventually were allowed to intervene into the matter. There was Renaissance Chiropractic, Centrum Physical Therapy, and Core Healing Bodyworks. As a result of the accident, the plaintiffs go on to file suit for PIP benefits from State Farm. Throughout the litigation, Plaintiff Tyler specifically failed to cooperate. She violated several court orders. She obstructed depositions. She eventually attempted to assault the defense attorney as well. But due to this, the defense attorney and the defendants, filed a motion to dismiss her claims for violation of court orders. Plaintiff Tyler informed the court that she had some psychiatric issues and claimed that it would be unfair to dismiss her claims. Based on those arguments, the court was lenient and denied defendant's motion to dismiss and gave Plaintiff Tyler another chance to cooperate. Unfortunately, she continued to be uncooperative, and she, in fact, did assault the defense counsel. Her claims were thereafter dismissed by the trial court, but interestingly enough, the trial court noted that the dismissal did not prevent the rights of her providers to intervene into the lawsuit. A year later, Plaintiff Tyler assigned her rights to her medical providers, Renaissance Chiropractic, Centrum Physical Therapy, and Core Healing Bodyworks. And that's when they moved to intervene. The trial court allowed them to intervene with respects to their claims of accounts and stated that this was now an unjust enrichment case, but they could not intervene as to claims for PIP benefits under the No-Fault Act. The interveners filed their complaint claiming that defendants conferred a benefit in the form of services provided and failed to remit payment, resulting in the unjust enrichment. Of course, defendant moved for summary disposition. Defendant argued on 4 grounds. 1, that the intervener's exclusive remedy was the No-Fault Act, as we all see in provider suits. 2, that any claim under the No-Fault Act was barred because it was derivative of Plaintiff Tyler's claim. Of course, the providers stand in the shoes of the plaintiff, or either barred by the 1-year back rule. 3, that the account stated claim failed to state a claim because there was no contractual relationship. And 4, the intervener's claim of unjust enrichment could not be sustained due to lack of evidence. The trial court denied defendant's motion and determined that there was a question of fact as to whether defendant received a benefit from the interveners that allowed them to bring a claim for unjust enrichment. Trial court also supplemented its order denying the motion, specifically stated that the unjust enrichment claim did not hinge upon the No Fault Act. The Court of Appeals went on to agree that the trial court erred when it acknowledged the intervener's claim for unjust enrichment. In its analysis, the Court of Appeals cited the Messner Law Group v. Weston Downs case, which ultimately stated that unjust enrichment claims require 1, receipt of benefit by the defendant from the plaintiff, and 2, the benefit must be inequitable that the defendant retained. In the Downs case, defendant did not receive any sort of benefit from the interveners. The only people that did receive a benefit from the interveners were the plaintiffs, i.e. Ms. Tyler, who received the medical benefit from the interveners. The interveners' one and only cause of action for reimbursement here was under the No Fault Act, making it subject to the provisions of the No Fault Act. This means that the intervener's claim would have been barred by the 1-year back rule as well. The Court of Appeals determined that the interveners were seeking recovery solely under the No Fault Act. Ultimately, the Downs case highlights that it is important for insurance companies to look for any claims that appear to be seeking no-fault benefits under any other guise other than the No Fault Act. Okay, moving on to trending topics in PIP litigation. Today I wanted to talk about proof of lost wages. Generally, a plaintiff's claim for lost wages fails as a matter of law if the plaintiff has not presented any proof that he or she lost wages but for the subject accident. No-fault work loss benefits payable under MCL 3107 for loss of income from work an injured person would have performed during the first 3 years after the date of accident if he or she had not been injured. Work loss benefits are intended to compensate the injured person for income he would have received but for the accident. The goal, as we all know, of the No Fault Act is to place individuals in the same but no better position than they were in before the automobile accident. I.e., plaintiffs cannot attempt to receive wage loss benefits if they're not working, or they can't attempt to receive more money than they would have if they were working. Before an insured may recover work loss benefits under the Michigan No Fault Act, the insured must show as a threshold matter that he or she was either employed or temporarily unemployed at the time of the accident. Temporarily unemployed sometimes gets a little sticky when it's hard to calculate someone's income if they're like a seasonal employer, or COVID made things very difficult in that arena as well. It's important to note that the insured is the one who has the burden of proof of the actual loss of earnings. Currently, I have a case where the plaintiff has attempted to argue that he makes approximately, for example, $100,000 a year, although his tax returns from the last 4 or 5 years show that he earns around $15,000 a year. I have not received any evidence throughout discovery that shows otherwise, and the only hardcore evidence I have are his tax returns. So unless the plaintiff in that case was to give me some sort of proof of his actual loss of earnings, I must rely on the proof that I do have. A wage loss claim must be based on actual wage loss rather than an impairment of future earning capacity. Michigan case law is also very clear that work loss covers only the actual loss of earnings, not loss of earning capacity. Therefore, if you did not have a job and you were unfortunately injured in a car accident, say your leg was broken, but you didn't have a job before, you cannot say that now I'm unable to work because my broken leg. You were unable to work even before you had the broken leg. Work loss benefits are meant to primarily provide claimants with simple income insurance and are intended to compensate claimants approximately dollar for dollar for the amount of wages lost because of the injury or disability. To recover, a plaintiff must generally show that he or she had a job, was involved in a motor vehicle accident, and that he or she had loss of income because of the motor vehicle accident. And they would have made that income but for being injured. Again, for lost wages, we must look to what a plaintiff can actually prove, not what a plaintiff has come up with in their head, has decided to testify to in a deposition. We need actual proof of loss of income, and that proof is based on the plaintiff's burden to provide to the defense. Moving on to the new fee schedule. This was an interesting issue of when the rights of a PIP claimant are vested in the new fee schedule. And I'm going to talk about the plaintiff's argument on when rights are vested versus the defendant's arguments of when rights are vested. Okay, based upon the old statute, the only prior limitation on the amount of medical providers charged was arising out of a motor vehicle accident was that it had to be reasonable and customary. As we all know, determining reasonable and customary has been somewhat difficult, and there's two separate standards. For example, balance bill on a suit for MRI charges. There's a large body of case law that has since been created addressing what information could be used to determine reasonableness. Changes to the old fee schedule took place on July 1st, 2021. Under the new fee schedule, the amount a provider can charge is being determined by the schedule itself. MCL 500-3157 as a whole remains relatively intact, but the statute now includes the schedule that limits the reimbursement rates. The fee schedule applies depending on the nature of the medical care provided. First, we would look to whether or not Medicare provides payment. If it does not, a different reimbursement rate is calculated through what's called the Charge Description Master. The Charge Description Master is a uniform schedule of charges presented by the person as its gross billed charge for a given service or item, regardless of the payer type. The rate is calculated by taking a percentage of the amount payable for the treatment or training under the provider's Charge Description Master, which took effect on January 1st, 2019. The provider did not have a Charge Description Master on that date, which means the percentage is taken from the average amount the provider charged for the treatment on that date. The amounts in effect on January 1st, 2019 are also going to be adjusted annually for inflation by the percentage change in the medical care component of the Consumer Price Index for the year preceding the adjustment. Again, on the fee schedule, we've now seen some case law, mostly orders from motions in the courts. Specifically, we're now seeing orders where judges are essentially saying that the rights of PIP claimants are vested when they paid their premiums and their injury occurred, so that the law that was in place at the time applies. So the reasonable and customary applies and not the fee schedule pursuant to no-fault reform. Of course, the defense argument is that when each individual claim for services was incurred is relevant. However, the plaintiffs are typically arguing the opposite. They're going to argue that when each individual claim for services was incurred is irrelevant. So basically, there's going to be a large number of claims where the plaintiffs are going to be arguing that the new fee schedules apply only to claims brought forth under contracts and/or for injuries/accidents that occurred after the amendments took effect. And of course, the defense would want to argue the opposite, that the defense would argue that the new fee schedule applies either way. The new fee schedule applies if the provider is in business currently, no matter when the accident took place. This is an interesting, evolving topic that I'm sure we're going to see much more case law on and much more discussion and motions. So because of that, because it's such a new and evolving area of law. I'm very interested in it, and I would welcome any questions you may have about this topic. And as always, thank you all for attending my PIP Monthly. Please feel free to contact us with any questions and or concerns. And again, my name is Amber Rouse Holloway. Thank you.